Has your insurance company denied your claim? They're not paying you any benefits and they're just like, sorry, we're not responsible. And you want to know, how can I fight this denial? Well, stay tuned. In this video, I'm gonna go through how do you know if the insurance company really is liable, and then I'm gonna share the process on how we change the no to a yes. Hi, I'm Naomi from Gonzalez Law, Legal Insights from California Attorneys. This topic is part of our mission to empower clients everywhere through education on the legal process. To support us in our mission, please like this video. First, I would like to give a shout out to our viewer Faisal Saeed, who requested this video. Thank you, Faisal. If my case is denied, how do I change the no to a yes and get it accepted? The answer is AOE COE Trial. What the heck is an AOE COE? It's an abbreviation for arising out of employment and in the course of employment. And this is a special trial. It's only on one issue. Is the insurance company liable for your injury? And it's only appropriate when your case has been denied in its entirety. Not even one body part is accepted. So is the insurance company liable for your injury? To be liable, 4 things must be true. 1, there has to be an actual employer relationship. The easiest way to prove that is if you are on payroll. However, sometimes people are paid under the table, or sometimes there's a problem where they are employed through an agency. We have the wrong employer or the wrong insurance company. 2, there has to be an actual injury. Just because you're having symptoms, maybe you have soreness, it doesn't mean that there's an injury. Usually some sort of objective findings that a doctor can use to say that yes, you have an injury. 3, that injury has to be caused from work or at work or because of work. This could happen if you're sitting at your desk and the chair breaks and you fall to the ground. Or it could be you're at a warehouse and a box falls in your head. It could be a lot of different things. 4, it must not be barred by an affirmative defense. Now, each of these affirmative defenses could be a video in themselves. So if you would want to see a video on one of these, please put it in the comments. Please know, even if you do fall into one of these categories, just don't assume that you cannot file your claim. Please call an attorney. There are exceptions, or your facts that you think fall into these categories really don't. So please call an attorney. Don't just assume that you're not eligible. 1, under the influence. Could have been under the influence of drugs or alcohol. Whatever it is, you're under the influence causes your injury. That would be barred by workers' compensation. 2, your injuries are self-inflicted. This does not mean that you had an accident that was your fault. It means you intentionally, willfully injured yourself. You walk into your office, get some scissors, and stab yourself in the stomach. That would be willful. That would be barred by workers' compensation. 3, suicide. Please do not commit suicide. And especially don't do it at work thinking your family's going to get death benefits, because they won't. It is not covered under workers' compensation. Do not do it. 4, initial aggressor. So if your injury is caused by a fight and you're the first one to throw the first punch, that would be the initial aggressor usually. But it could also be you're the one that's causing the situation. You back the other person into a corner. There's no way that they can get out. It has to become physical. So whoever is the first aggressor, they will be barred from workers' compensation. 5, felony. You're committing a felony at work and get injured. Not covered under workers' compensation. For example, you work at an expensive jewelry store and you think one day, I'm gonna just grab some jewelry, put it in my pocket and run out the door. And as you're running out the door, you slip and fall, hurt yourself. Not covered under workers' compensation. So my recommendation is don't commit a felony at work. 6, voluntary recreational activity are not covered under workers' compensation. So for example, let's say your office has a office team for baseball. You decide you're gonna participate. They're not saying you're gonna get paid. It's not mandatory. And you are the catcher. Someone hits a home run, or we think it is, and they start running, right? They run to first, they run to second, they run to third. They're about to come home, but your team has thrown the ball to you now. You catch it, you're gonna tag them, they're sliding into home, and as you tag them, bend your thumb backward and it breaks. That happened to my brother, by the way. Not covered under workers' compensation. 7, post-termination defense. So this is the case where you have an injury, you don't report it to anybody, then you're terminated, and then you try to file. Filing after you were terminated. That will be barred in workers' compensation. Say one day that you're walking and you slip and fall and you hurt yourself, but you don't tell anybody. You don't report it to your employer, you don't fill out any paperwork, you just keep quiet about it. You decide, just put icy hot, maybe you call off the next day, don't say anything. Then a few months later, they decide they're gonna fire you. Maybe you're terminated for cause, or maybe you were just laid off. And then later you're like, ooh, maybe I should have reported that claim before because I'm still having pain. You should have, by the way, report it right away to your employer if you're injured. So now you try to file. Well, that's going to be barred, but contact an attorney. Don't just assume that you can't do it. 8, the going and coming rule. If you are in this position where you drive to work and you drive back from work and you drive to work and you drive back from work, one of these days as you're driving to work, you get in a car accident. That injury is not going to be covered under workers' compensation usually. Definitely contact an attorney because there are exceptions to that rule. 9, jurisdiction. Jurisdiction is a defense that's claimed if they think that California is not the correct place to be. They might think a different state is more appropriate for your injury. 10, statute of limitations. In California, for workers' compensation, the statute of limitations is 1 year from your date of injury. So make sure that you're not sitting on these. You want to file right away. Please understand that workers' compensation is a no-fault system. It doesn't matter if it's your fault or somebody else's fault that you were injured. If you're injured at work, your employer has to cover your injuries, with the exceptions being the ones we just went over. So now you know the insurance company is liable for your injury. What do you do from here? First, your attorney will be gathering all the evidence needed to proceed on this claim. You need medical evidence. The strongest medical evidence is if you have 2 reports, one from the qualified medical evaluator and one from your primary treating physician that's within the MPN. If they are both saying that you have an injury and it's from work, you are good. If you don't have 2, but you only have 1, you can still proceed to trial. The very weakest amount possible to win is if you have a primary treating physician that is a lien doctor that's saying that your injury is from work. The second thing that your attorney will have to gather is evidence if the defense is asserting one of those affirmative defenses. Now that could be witness testimony, medical documents, video footage. It could be a lot of things that is gonna particularly fight whatever it is they're asserting. So for example, if they're saying you're not an employee, but you have checks that they wrote you under the table, have their signature, you're gonna want those documents. But you would have to look at each of the affirmative defenses to have evidence customized for that particular defense. Now it's time for step 2. You file a DOR for a priority conference. A DOR is a declaration of readiness to proceed, and it's paperwork you have to file to get a hearing with the Workers' Compensation Appeals Board. Once you file that, you will have a hearing date for your priority conference. Step 3, you go to the priority conference and you ask the judge to set your issue for trial. The judge will either decide yes or no. If they say yes, step 4, a pretrial conference statement. Your attorney will fill one out for you and put there your exhibits and also any witness testimony that they're planning to use. Step 5, you go to trial. Please note these are administrative trials. They are not jury trials. You may be called as a witness at this trial or you may not, depending on what you and your attorney decide. Definitely all of the evidence will be submitted. The judge will be making a decision. If the judge does decide that the insurance company is liable for your claim, then they will need to start paying benefits. If you have any questions on those benefits, I will link to my video on benefits. Something of note, at the priority conference or at the trial, the other side will see your evidence. And if they feel like, you know what, we're not going to win this thing, they may just accept your claim without having to go to trial. Or they might accept only one body part for AOE COE trial to stop. Once you have one body part accepted, AOE COE trial is no longer appropriate. It will go off calendar. But you will at least be able to start receiving benefits for that body part. You don't have to develop everything at the same time. You have a claim that has elements of orthopedic and psychological, and you've only developed your orthopedic part so far. You can still proceed to AOE COE trial only on the orthopedic part. So that's AOE COE in a nutshell. I hope this was valuable for you. If you have any questions or you would like us to discuss your specific case, please call us or text us consult and we'll be very happy to talk to you. Actually, texting consult is the fastest way to get a hold of us. Thank you. Bye. 4 fist punch, face, stomach, face.